Start. The tribunal in its order has observed that by the earlier order of the tribunal as upheld by the High Court, the disciplinary authority has been mandated to reconsider the quantum of penalty, as it cannot impose the penalty of removal from service under the facts and circumstances of the case. Stop. The tribunal observed that while admitting the fact that in a number of cases minor penalty was imposed, in some cases censure was imposed, and in certain other exoneration was imposed. Stop. The order dated 26th April 2002 has attained finality when the writ petition against the same was dismissed in 2002 and the disciplinary authority has chosen not to move the matter before the apex court. Stop. In that event, whatever may be the cause of justification, there is no question of same order of removal from service being passed. Stop. The authorities have exceeded the jurisdiction. Stop. The impugned order of penalty as well as that of appellate order are therefore liable to be set aside. Stop stanza. Learned counsel for the petitioners submitted that the tribunal in its order dated 26 April 2002 has affirmed the inquiry report as well as the order of the disciplinary authority to the extent that the charges levelled against the respondent stood proved. Stop. Therefore, the order of the tribunal to this extent has not been set aside or modified by the writ court. Stop. Thus, the order of the tribunal to the extent that the charges stood proved attained finality. Stop. The only question remained for consideration by the tribunal was that whether on such proved charges what quantum of penalty should be awarded. Stop. While remanding back the case, he submitted that the tribunal has not been held that the penalty of removal from service is wholly unjustified and should not have been awarded or some other penalty would have been awarded. Stop. The tribunal has remanded back the case to the disciplinary authority for consideration of the quantum of punishment afresh. Stop. It does not mean that the disciplinary authority was prohibited or restrained from levying the penalty of removal of respondent from service. Stop. The disciplinary authority on the facts and circumstances and the charges levelled against the respondent having been found proved rightly was of the view that it is a case of embezzlement of public fund and of a misconduct for which appropriate penalty would be the major penalty, that is the removal of respondent from service. Stop. Therefore, the view of the tribunal would be the major penalty of removal from service cannot be passed by the disciplinary authority is not justified. Stop. He submitted that the respondent has to follow the procedure provided under rules which specifically provides that the money against any money order is to be delivered at the address after proper verification of his identity, whereas in the present case the same have been delivered not at the place of the addressee but at the post office itself, and that too without proper verification of the identity of the addressee to a bogus person. Stop stanza. Thus, it is clear-cut case of non-following the proper procedure provided under the rules embezzlement, misappropriation of public fund. Stop. Therefore, it is a case of misconduct. Stop. The postman holds a post where he used to handle public money, and as such he is supposed to be the man of integrity, and his job is based on the faith and trust. Stop. The respondent was bound to deliver the money against the money order to be genuine and eligible person who was entitled to receive the money at the addressee's place of residence after proper verification of his identity, which he completely failed to do, and therefore major penalty awarded by the disciplinary authority of removal from service was wholly justified. Stop. He submitted that no parity can be claimed for an illegal act. Stop. Even though the case of the respondent is entirely different to other cases, but even if it is assumed that the facts of the case are similar to the other cases where minor penalty has been awarded, then also an illegality cannot be permitted to be perpetuated. Stop stanza. It is also relevant to indicate that the appellate court, while allowing the special appeal, even though at that point of time the mother of the petitioner had not been acquitted, keeping the equity in favor of the petitioner, had passed an order by which a direction was issued to the respondents to consider the claim of the petitioner for compassionate appointment. Stop. It is also apparent from the record that while allowing the appeal, the appellate court was conscious enough that considerable time has lapsed, but in spite of this fact that the mother of the petitioner had not been acquitted at that point of time, the appellate court had directed for consideration of the appointment of the petitioner on compassionate ground in place of her mother. Stop. Therefore, at this stage, taking the view that substantial time has lapsed and on the basis of law laid down by Honorable the Apex Court in Umesh Kumar Nagpal Supra, the claim of the petitioner cannot be considered, cannot be sustained. Stop stanza. The records clearly indicate to this court that earlier writ petition number 7638 of 1995 was filed by the mother of the petitioner, which was allowed on 23 to 1998 with direction to give her compassionate appointment on class 4 post. Stop. The respondents did not comply with the same and preferred special appeal number 1384 of 2009, which was also allowed on 9/9/2014 with specific observation and direction for consideration of the claim of the petitioner instead of her mother for compassionate appointment. Stop. Therefore, at this stage, the respondents cannot take plea that substantial time has lapsed in between. Therefore, on this ground, the claim cannot be rejected. Stop. The respondent authorities are not empowered to substitute their own view over the judgment of the division bench. Stop. Either the respondent authorities should challenge this point before the division bench, or they should file recall application, or they should approach Honorable the Apex Court in this regard. Stop. But as the respondents have not adopted any of the aforesaid step and has not filed any appeal against the aforesaid judgment of the division bench, it is binding on the respondent authorities and they cannot substitute their own view over it. Stop. Every case has its own facts and circumstances. Stop. In this case, the mother of the petitioner has suffered double jeopardy. Stop. Her husband was not only murdered, but she was also falsely implicated in the murder of her husband. Stop. Her husband was murdered on 4/5/1994 and she was honorably acquitted on 24/11/2014. Stop. It has shaken the conscience of the court that how she could have maintained her family and proved her innocent in the criminal case for the murder of her own husband. Stop. The division bench, considering the facts and circumstances of the case and extreme difficulty faced by the mother of the petitioner, taken a sympathetic view and directed the compassionate appointment of the petitioner. Stop. Non-compliance of the order of the division bench without being raised before Honorable the Apex Court can be said to be contemptuous, and it is not open to the respondents to defy the same stop stanza. In view of the aforesaid facts and circumstances, the writ petition is allowed. Stop.